And welcome to this meeting of the Standing Committee on Social Development. We are here May 29th to review Bill 72, Opioid Damages and Healthcare Cost Recovery Act. I'd like to start off by asking members to introduce themselves this evening, and I'll start off with the member to my left.
Jane Whalen Armstrong, MLA for Mopi.
Lisa Semler, MLA for Nuvik Twin Lakes.
And I will turn it over to members who are joining us online, starting with MLA Knockleby.
Katrina Knockleby, MLA for Great Slave.
Ron Bonjus, Decho.
Must-see members, and also for staff in the room joining us this evening, we have Mahalia Gaklaya Newmark, who is our committee advisor. We have Amy Lizotte, who is our committee clerk, and then at the back of the room, we also have Toby Kruger, who is our law clerk. My name is Caitlin Cleveland. I am the MLA for Cam Lake, and I am also the chair of this committee. This evening, the Standing Committee on Social Development is reviewing Bill 72, Opioid Damages and Healthcare Cost Recovery Act. This bill is available on the Legislative Assembly website. Bill 72 received second reading in the Legislative Assembly on March 2nd, 2023, and was referred to the Standing Committee on Social Development for review. I would now like to call on the Honourable R.J. Simpson, Minister of Justice, to deliver any opening remarks on Bill 72. Following the Minister's remarks, committee will proceed with a clause-by-clause review. Minister Simpson, please introduce your staff for the record, and the floor is yours.
Thank you, Madam Chair, for inviting us here to present Bill 72, Opioid Damages and Healthcare Cost Recovery Act. Today, I am joined by Maren Zimmer, Legal Counsel with the Department of Justice, and to my left, Laura Jeffrey, Legislative Counsel with the Department of Justice. The purpose of Bill 72 is to permit the government of the Northwest Territories to file a lawsuit to recover past and future healthcare costs incurred on behalf of Northwest Territories residents for opioid-related illnesses from manufacturers and distributors of opioid drugs. The opioid crisis has incurred substantial costs to federal, provincial, and territorial governments who have spent increasing amounts on healthcare to address the fallout of the opioid overprescription. British Columbia has enacted its own opioid cost recovery legislation and is in active class action litigation before the Supreme Court of British Columbia. This action could include all federal, provincial, and territorial governments as potential class members in this lawsuit, and seeks to recover the opioid-related healthcare costs of the potential class members. Currently, the GNWT's ability to independently recover opioid damages is in question, as the applicable limitation period has expired under the Limitation of Actions Act. As our legislation stands, the GNWT may be unable to recover healthcare costs under British Columbia's opioid action. The proposed legislation would not only remove the existing limitation period barrier to such a claim, but also improve the likelihood of the opioids action success by establishing a common issue across all jurisdictions with that legislation. This would simplify the advancement of the opioid action. The proposed new act will provide a statutory basis to sue manufacturers and distributors of opioid drugs directly for opioid-related wrongs, provide the ability to sue opioid producers and distributors on an aggregate basis without having to identify particular insured persons who suffered harm, provide a simplified formula to determine the individual share of liability for each opioid producer and/or manufacturer named in a lawsuit, provide the ability to base claims of harm on statistical and sociological data, and extend limitation periods applicable to actions based on opioid-related harm. Approximately 8 other jurisdictions have enacted their own versions of this legislation, and the wording of the proposed new act is virtually identical to the existing legislation in other jurisdictions. This concludes my opening remarks, and I will be pleased to answer any questions members have regarding Bill 72. Thank you.
Thank you very much, Minister. Members, does anyone have any questions or comments for the Minister? Hearing none, does the committee agree to proceed to a clause-by-clause review of Bill 72, Opioid Damages and Healthcare Cost Recovery Act? Where possible, I will call clauses in groups. Does committee agree? Committee, we will defer the bill number and title until after consideration of the clauses. Please turn to page 1 of the bill. Clauses 1 to 5, does committee agree? Clauses 6 to 10, does committee agree? Clauses 11 to 13, does committee agree? Schedule, does committee agree? We will now return to the bill number and title, Bill 72, Opioid Damages and Healthcare Cost Recovery Act. Does committee agree? Does committee agree that Bill 72, Opioid Damages and Healthcare Cost Recovery Act is now ready for consideration in committee of the whole? Emily Semler?
I move that Bill 72, Opioid Damages and Healthcare Cost Recovery Act, be reported to the Assembly as ready for consideration in Committee of the Whole.
There's an order to the motion. Question has been called. All those in favor? All those opposed? Motion is carried. Bill 72, Opioid Damages and Healthcare Cost Recovery Act, will be reported to the Assembly as ready for consideration in Committee of the Whole. Thank you, Minister, and to your staff as well for joining us here this evening. Members, this concludes the public portion of our meeting. Can I please have a motion to move in camera? Thank you, Emily Whalen Armstrong. We are now in camera.